Hello everybody, this is first of 4 documents that were filed today that were supposed to be filed yesterday by Colborn and his team. Michael Griesbach's supplemental brief on Netflix motion to compel compliance with subpoena. The court directed parties to file simultaneously supplemental briefs explaining the impact of Wisconsin's reporter privilege, including any applicable waiver of privilege on Netflix's motion to compel. The respondent wishes to clarify at the outset that the reporter privilege is the basis for his objection to document requests number 1 through 6. Only document 207, Exhibit 1. The respondent's objections to the remaining requests are based on other grounds that have been argued at length in parties' briefs and will not be repeated here. An additional preliminary matter, the respondent does not understand Netflix has been engaged in public for an entirety described in paragraph A. Among the entities enumerated at par, the book publishers, thus the respondent fails neatly under the definition of newsperson. Netflix has not claimed otherwise. Netflix failed to meet the strict procedural of substantive requirements in Wisconsin reporter privilege statute compel disclosure. The procedure for a subpoena a news reporter in Wisconsin is markedly different than for subpoena anyone else. Only a court can issue a subpoena to a news reporter, and only after a person requesting a subpoena has met a rigorous showing justifying why disclosure should be compelled. Subpoenas issued to news persons, prohibition, except as provided in par. No person having the power to issue a subpoena may issue a subpoena compelling a news person to testify about a procedure or disclose any of the following that is obtained and prepared by the news person and news person's capacity in gathering, receiving, and preparing news information, potential dissemination of the public. Procedure before courts, subject to par. The circuit court may issue a subpoena to compel a news person to testify about a disclosure procedure in any news information, identity of source specified in paragraph A, and court finds after notice to an opportunity to be heard by a news person. Netflix ignored the statutorily mandated procedure by subpoena the respondent directly without making application to the court. The subpoena also requested non-privileged documents and is not a reasonable excuse for the respondent to unaware of any case suggesting otherwise. Moreover, Netflix would be hard pressed to claim ignorance of the requirement since one of the lawyers in the action has written extensively Wisconsin reporter privilege, including stringent statutory procedural requirements, the news information, identity of source, the necessary maintenance of parties' claim defense, or the proof of issue material, investigation, prosecution, action, and proceeding. The news information, identity of source is not obtainable from any other alternative source for investigation, prosecution, action, or proceeding. There is an overriding public interest in the disclosure of news information, identity of source. Rather than trying to meet these proofs, Netflix repeatedly, but wrongly, insists that the federal general rules of discovery apply, going so far as to represent that. Thus, the only issue for the court to determine whether the subpoenaed materials meet the broad standard of relevance in discovery. And it's no wonder that Netflix mischaracterizes the applicable standard, for it cannot meet the stringent criteria to overcome the privilege set forth in the reporter privilege statute. Having scoured the 540 pages of the text in the respondent's book, Netflix cites a handful of inconsistent experts and the commands of the respondent to turn over myriad of privileged documents. In none of these citations does Netflix come close to meeting 88514 rigorous standard to compel disclosure. First, Netflix points to the respondent's recounting of one of his books in a conversation he overheard among coffee shop patrons concerning their impressions of the Avery trial as proof that he possesses relevant information about the damage to Mr. Colborn's reputation before making a murder aired. Netflix would be hard-pressed to prove, as they must under 88514, that the coffee shop patron's opinions are highly relevant and necessary for this defense, or that he can't obtain similar information from alternative sources, or especially that overriding public interest requires disclosure of patrons' names or other information the respondent might have about them. Similarly, the fact of Mr. Colborn's colleagues was upset that a police officer falsely accused of planting evidence by a criminal defense lawyer during trial as little as any legal resource. Document 206, motion to compel, page 14. It's neither highly relevant nor necessary for Netflix's defense. Not that it's overriding public interest in the disclosure of the officer's frustration. The same holds true for respondents sharing with the readers that the quirky circumstances of the investigation scared him, especially how Colborn and Link were the ones to find the keys. Key, not keys, key. And the prosecutor's attempts to soften the blow of evidence ran hollow to many. Document 206, motion to compel, page 14. Netflix can surely find other observers of Mr. Avery's trial who are inclined to believe that the police planted evidence to frame him. Indeed, they have. Document 84, attachment Exhibit 1, Second Amendment complaint, page 36 to 37. Experts for Making a Murder, episode 3, depicting a number of Manitowoc County bar patrons expressing their opinions. The police framed Mr. Avery. The same is true for a respondent opinion on one of his books that the police officers looked more defensive during the depositions than they should have if they had nothing to hide. Motion to compel, document 206. Netflix can make the point without restoring to the subpoenaing one of the plaintiff's lawyers. The final book experts cited by Netflix that either Mr. Colborn or one of his colleagues' hopes for a peaceful Christmas Day were dashed by telephone calls from angry viewers of Making a Murder. At least compelling of all. If the respondent was referring to Mr. Colborn, Netflix argues the statement obviously undermines Mr. Colborn's claim that Making a Murder destroyed his marriage. Aside from the logical interference, Netflix is more than capable of digging into the demise of Mr. Colborn's marriage in other ways. Having come up woolly sort of experts and sites, Netflix cannot meet its statutory burden by simply claiming it does not in its reply brief. Its disguised in motion to compel, or that examples are not only proof that the respondent has relevant discoverable materials, Dr. 221, more than self-serving speculation. Netflix has come up hopefully short. Despite these fundamental procedural and substantive errors in the interest of a judicial economy and acknowledgement, the both parties have more procedural missteps. The respondent does not seek relief on the basis of Netflix procedural serious error. The court should not deem the respondent waived the protection afforded him under Wisconsin Reporter Privilege Statute by his noncompliance with Rule 45 of the Federal Civil Rules of Procedure. Netflix argues the respondent waived his privilege claim by not including it in his written objections and not describing the nature of withheld documents required by Federal and Civil Rule 45. While conceding this is error, the respondent submits to the reasons stated below that court should not deem the privilege waived. While violations of Rule 45, the Federal Rules of Civil Procedure, can result in waiver is not required. As the court stated, First Ave Bank FSB versus First Bank System Incorporated, 902 156 995, acknowledging the harshness of waiver sanction, courts have reserved the sanction for those cases when the offending party committed unjustified delay in responding to discovery, minor procedural violations, good faith attempts of compliance, and other such mitigating circumstances milate against finding waiver. The Seventh Circuit has stated sanctions may only be imposed where a party displays willfulness, bad faith, or fault. More importantly, when the disclosing party raises untimely objection on the grounds of privilege, court have noted waiver particularly severe. Courts have considered the four factors when deciding whether sanction discovery violations. 1. The procedure of surprise the party against whom evidence is being offered, the ability of party to cure prejudice, the likelihood of distribution of the trial, and bad faith or willfulness involved in disclosing evidence at an earlier date. Here, Netflix has not been prejudiced by the late privileged objections, although not raised in the initial responses. Netflix appraised the privilege issued during a meet and confer prior to bringing its motion to compel. The delay is relatively brief in the context and lengthy time period Mr. Colborn's case has been pending and will not cause prejudice or disruption in the trial. Discovery is still open, and with this issue thoroughly briefed by the parties, it will soon be resolved. Finally, and perhaps most significantly, there is no evidence that respondent's procedural error was made in bad faith, and Netflix does not appear to argue otherwise. Even if a technical waiver would ordinarily result, the respondent's failure to comply with the Rule 45 involves constitutional considerations which require special considerations relating against waiver. Court with the Seventh Circuit has recognized the waiver may be relieved and constitutional concerns are present. Where constitutional privilege is involved, the trial court possesses discretion and not find a waiver. Although courts have stated the constitutional privileges are not inherently self-executing, waiver of constitutional rights and not likely inferred, courts must indulge every reasonable presumption against waiver. Although these cases do not directly address the reporter privilege, arguably all constitutional privilege is subject to heightened standard due to the nature of the underlying rights of the importance. Further, respondents' procedural errors should not result in a waiver when Netflix ignored the more fundamental requirements set forth in Wisconsin's privilege statute, as explained in Section 1 above. Party seeking a subpoena and news reporter must apply to a court and prove that the requestee criteria encompassed under Wisconsin Statute 88514 be clear and convincing evidence before a valid subpoena is issued. Having chosen not to comply with this essentially mandated procedure, Netflix is not in a position to complain with the respondent's, relatively speaking, more minor procedural error. The respondent, unaware of the case, identifying the proper remedy to fail to comply with, but other technical deficiencies have held an invalid subpoena. Devereaux, Manam, Incorporated, 93 C06, blah, 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 in 1994. Determined the subpoena was an incorrect district in the heading of the valid denying the motion compelled based on availability. Let's see. This is a bunch of bullshit. Applied court meets statutory criteria subpoena the respondent significantly with fundamental deficiency and the minor technical errors held to invalidate subpoenas in the cases cited above. Logic proves no reason why Netflix's more serious error should be treated differently. Additionally, as indicated above, Netflix failed to respond to his motion to compel despite being notified of the respondent's privilege claim at the meet and confer. Courts have held arguments raised for the first time in a reply brief and waived still worse, and also required above. Netflix chooses to apply an acceptable standard of relevance in the reply brief rather than correct the standard set forth. Under all circumstances, Netflix's insistence of the respondent should be held to strict compliance while it should be revealed its more fundamental error clearly unwarranted. The respondent did not waive protection afforded him by the Wisconsin Reporter Privilege Statute by agreeing to represent Mr. Colborn. A disclosure to another person, dissemination of public news information of the identity of source are described as such by a news person does not constitute waiver of protection from compelled disclosure under subsection 2 or 3. The respondent unaware of any case law in Wisconsin interpreting the provision as such as the court must apply Wisconsin law attempting to predict how Wisconsin Supreme Court rules on the issue. And they're stating a bunch of cases. Another framework, statutory interpretation begins with examination of the plain meaning of the statutory language in which the term is given common, ordinary, accepted meaning, where the plain language is unambiguous and analysis ends and other extraneous sources are not consulted. Especially states that disclosure of any of another person does not amount to waiver. The statute does not facilitate or officially place the qualifications on who another person may or may not be. Instead, the statute awarded to protect disclosure of any other person, regardless of the relationship between the reporter and the person. The statute contains nothing to suggest the respondent's communication with Mr. Colborn or counsel are precluded. Instead, broadly precludes waiver whether information is disclosed to another person. Additionally, Wisconsin's anti-waiver protection applies to disclosures made by news persons, which are also broadly stationally defined and includes any person who has been engaged in gathering and receiving news or information to the public. As such, a statute clearly contemplates protection for the news person previously engaged in news reporting activities. They arguably are not currently acting in the capacity distinction crucially because the case relied upon Netflix, Simon versus Northwestern University. The court largely took issue with the reporting acting in another capacity that a lawyer, unlike Illinois' Wisconsin legislator, saw fit to create a broad anti-waiver provision which applies to newspersons that make disclosure to any other person if they are not currently engaged in news reporting. No statutory language indicates the disclosure of the client. The text of the Illinois reporter's privilege is materially different from Wisconsin's. While Illinois has confided in its own version of reporter's shield statute, nothing in the statute addresses waiver. In fact, courts in the Northern District of Illinois have expressly noted that the statute is silent in questioning whether the report might waive their privilege by her conduct, and case law addressing the question sparse. The facts assignment seemed well in the assignment. The court determined that the news reporter, in the case of documentarian, who becomes counsel for a party in litigation, waived protection under Illinois' reporter privilege. Although cursory review suggests that the case is factually similar, in-depth analysis reveals several significant distinguishing facts. The attorney in the assignment, Mr. Hale, was far more involved in underlying legal dispute than respondent was in the case. Hale and his team included jailhouse interviews, other investigative techniques far beyond the research respondent conducted in preparation for writing his books. Hale's documentary, A Murder in the Park, ultimately led to the release of Mr. Simon, who had been convicted of murder after falsely confessing to the crime. While the respondent's hands become embroiled in the controversy surrounding Mr. Avery's murder conviction in virtue of authoring some books, his efforts had no effect on the outcome of Avery's conviction's multiple failures on appeal. Significant to the court assignment was defendant's comparative disadvantage by Hale's representation in the plaintiff's counsel. The court explained had access to relevant information not available to defendant's counsel. There's such inequity here. Have relied almost exclusively on publicly available documents. Respondent possesses little, if any, relevant information that Netflix does not already have. Netflix has tried to but failed to show otherwise in the party's filings to date. Indeed, Netflix has turned an inadequacy on its head. The producer defendants spent 10 years complying countless interviews and listening to defendants. Netflix responded who has wealth, information, and credibility. But they also got to take into consideration that Netflix talked to all the law enforcement people in this case too, but when it came to them releasing what they gave to them, they all denied and didn't sign over to release the information to be included in the documentary. That's why they were stuck to just using what happened in the court. Ignoring these factual determinations, Netflix, none of the two subtly accusers, responded of bad faith. By cutting Simon Court's commentary privileges statutes were clearly not meant to be used as a vehicle for a party to initiate litigation and retroactively use reporter's privilege to keep information out of discovery. Netflix ignores the significant distinguishing fact that they were aware while Hale joined a legal team in place within a week of Simon's release and well after the complaint had been filed. The respondent filed a complaint as sole as counsel. Mr. Colborn's attempt to secure other counsel failed at the last possible moment before the statute of limitations expired. It appears that Simon's court cautionary noted against reading too much into the decision was lost on Netflix. Thus, we caution that the presidential value of the opinion to resolve waiver under Illinois' reporter privilege should be considered cautiously. The issue waiver under Act complex, very factual driven. The factual scenario presented here is extremely unique. We believe that the legal analysis waiver in other contexts would require more detailed considerations. It is generally unwise to ascribe another's motivation and litigant attorneys, but it is difficult not to suspect Netflix is seeking something other than documents from the respondent that it neither needs or entitled to. Undoubtedly, to the court's jargon, the lawsuit plays out in the context of ongoing public controversy between supporters of Mr. Avery, his past and current attorneys, and Netflix procedure. Producer defendants on one hand, those who have dared to cry foul and attempt to reboot Making a Murder's false claims on the other. Netflix should receive whether Discovery is entitled to under the law, but it should be permitted to conflate Mr. Colborn's lawsuit and respondent's books of the executive producers work on yet unsold competing documentary to distract, harass, and embarrass. Document 222, Declaration of Isabella Nascimento, with accompanying 5 exhibits. The respondent respectfully asks the court to take reality into account as it considers the facts acceptable by law. Conclusion. For all these reasons, for the reasons set forth in the initial brief, respondents respectfully request that the court deny Netflix's motion to compel. What a surprise. Well, this is document 241, and then 242 is just a declaration of Michael Griesbach stating under penalty of perjury and subject, I am a plaintiff's attorney in the case and also responded to the document subpoena, the subject in the motion to compel and instant brief. On March 11, 2022, my former attorney, John Mayer, conducted a meet and confer via telephone conference with Netflix counsel Lita Walker regarding the subpoena Netflix served upon me. I was an attorney in Mayer's office at the time. The law firm of Manitowoc during the time the meet and confer could hear the entire conversation as Attorney Mayer's speakerphone was on. During the conference, Attorney Meyer informed Ms. Walker that among the objections to the subpoena was the majority of document really requested called the production of documents that were privileged under Wisconsin's reported privilege statute. I declare under penalty of perjury foregoing to true and correct. June 8th, 2022. So they're still trying to hide under this reporter privilege thing just so he doesn't have to turn over all his information, which I think is bullshit. Because he's not a reporter. He was a district attorney that wrote a book. And he had first-hand knowledge that nobody else had access to. Like the documents that were inside the safe during his... Yeah, I don't know. But there's 2 more documents I still got to read, so I'll be back in a little bit and bring the information to y'all when I get it. Y'all have a good day.